Hello, and welcome to another edition of ABI Podcast. I'm Professor Drew Dawson of the University of Miami School of Law and the ABI Robert M. Zinman Resident Scholar for the spring of 2017. Today I'll be talking with Professor Matthew Bruckner, an assistant professor of law at Howard University, where he teaches bankruptcy, contracts, and consumer finance, among other business and commercial law courses. Professor Bruckner's research on bankruptcy in the higher education sector has been extremely important and timely given the wave of distress hitting many higher educational institutions. Professor Bruckner's article, Bankrupting Higher Education, will soon be published in the American Bankruptcy Law Journal, and his most recent article, Higher Ed Do Not Resuscitate Orders, is now available on the Social Science Research Network. Links to both articles are available in the ABI newsroom. Matt, thank you for joining me today.
Drew, thanks for having me.
So we've seen more institutions of higher education closing their doors and just shutting down. What's happening in this sector?
So, yeah, that's right. About a little over 700 colleges of all stripes, technical school, for-profit colleges, nonprofits, and the like, closed just last year. And surveys of bankruptcy professionals have suggested that higher education is one of the sectors they think are in the most financial trouble these days. And there seems to be a number of possible causes, and some of them are common issues, and some of them break down by the type of entity. So, for example, in my pieces I refer to public colleges, private nonprofit colleges, and private for-profit colleges, often just for-profits. So the public colleges seem to be struggling because of declining state funding. So Louisiana, for example, a couple of years ago had proposed slashing their higher education financing by 82%, precipitating Louisiana State University to prepare a financial exigency plan. Now, some of that was walked back, but budget cuts are expected in the future in a number of states. Some colleges struggle because of overexpansion. So, for example, Burlington College up in Vermont, which was run by Jane Sanders, wife to presidential candidate Bernie Sanders at the time. They decided that the thing their college really needed to improve was to buy some prime real estate in Burlington and expand their campus. They took on a lot of debt. I think the purchase was about $12 million. And that was debt funded. The expectation was they would double their enrollment once they were on this shiny new campus on the lakefront. But it turns out their optimistic enrollment projections were incorrect, and they needed to unload this real estate, and ideally would have just unloaded the real estate and returned to their former model. But because they lacked access to bankruptcy reorganization, that just wasn't an option for them.
Yeah, that sounds like exactly the sort of thing that bankruptcy normally deals with. We see that right in the retail sector in particular. Overexpansion, bankruptcy provides an opportunity to reject the leases and sort of get back to like a manageable footprint. When you say there's no bankruptcy eligibility, though, where does that come from?
Yeah, so I certainly should be clear on that. So I often will say that bankruptcy organization is not available, or sometimes even you'll catch me saying that there's a bankruptcy ban. What I mean is that there is not a legal prohibition on a bankruptcy filing, but that if a college or university, technical school, if they file a bankruptcy petition, they immediately and irrevocably, automatically lose access to Title IV funding. Now, Title IV, as some folks may know, is the federal student loan and grant program. So it's your Pell Grants, your Stafford loans, your Grad Plus loans. And many institutions are heavily dependent on these on Title IV funding, and without it, they just can't continue. And so it's really more of an economic prohibition, cutting off a critical source of funding, than it is a legal prohibition.
Okay, so it's different. Right? Section 109 of the Bankruptcy Code, for instance, excludes certain types of entities from bankruptcy relief altogether. What you're pointing out is they're effectively barred. But as you mentioned in your paper, there's something really different about these higher educational institutions, because financial institutions and other institutions excluded, other types of businesses excluded under Section 109, often have some other relief available, which is not the case with the higher education. Is that right?
They don't have a reorganization provision, right? So, for example, banks or bank holding companies, which are excluded under Section 109, are typically reorganized through an FDIC receivership. And so while there are other options, because it's not a legal prohibition, for example, a college can liquidate in bankruptcy, and there are other options like receiverships or assignments for the benefits of creditors, there does not seem to be another viable reorganization option. And as you said, the type of distress that Burlington College experienced seems like the sort of typical debt overhang, overexpansion sort of problem that bankruptcy can solve. Now, that doesn't mean that they can solve the problems that all colleges face. For example, Sweetbriar College down in Virginia, their trustees, I think somewhat famously recently, had decided to close the college and wind things down. And although they were kept open for the time being, the reason they were closing, or the trustees wanted to close them, was because they thought that students simply did not want to come to a single-sex institution, rural institution, I think their primary program was something like equestrian studies, and the trustees just made the choice that this was more like the sort of a vacuum tube or a buggy whip, and bankruptcy, if it were available, might not have been able to solve Sweetbriar's problems.
We've also seen, and most recently in the Marblegate decision, we saw with Education Management Corporation trying to reorganize outside of bankruptcy. And while most of the discussion of that case focused on the Trust Indenture Act, and the background of all of that was the fact that they were forced to try to reorganize outside of bankruptcy for the exact reason you mentioned, that a bankruptcy filing would have necessarily and inevitably led to a liquidation. You mentioned the paper.
We talk a little bit about it. The comparison that sort of comes to mind for me is Thomas Jefferson School of Law. So Thomas Jefferson, it's how I got into this topic in the first place, right? They defaulted on their bond obligations on their brand new law school building. They were held out by a lot of the sort of law school watchers as the type of law school that everybody expected would close. It's, standalone in a competitive marketplace. And then they didn't close. Right, and their bondholders entered into a consensual workout with them because it seemed like the best use of their brand new law school building was unsurprisingly, as a law school. But there was perhaps just because it was a smaller entity, it was just easier to negotiate with the creditor body, whereas EDMC is a huge institution, just like Corinthian colleges and Anthem, ITT Tech, and they're just much less likely to be able to use sort of a consensual out-of-court restructuring process. So, I think it's an interesting difference between the sort of large for-profits, right? They're the most like retailers. They're the most like other traditional businesses, and therefore, in some ways, the most likely to benefit from bankruptcy, which makes the sort of maybe the political case that much harder for changing the law.
Yeah. Now, before we move on, because in your newspaper you draw some comparisons from healthcare, but before we move on to the healthcare industry comparison, can you fill us in a little bit? Why is it exactly that Congress decided to effectively make bankruptcy unavailable for higher educational institutions?
So it's not 100% clear. There's no legislative history that accompanies the changes. What there is, or what there was, were a series of high-profile hearings in the Senate investigating, in particular, the for-profit college industry. And there were a lot of concerns expressed about profiteers opening fly-by-night institutions, defrauding their students, taking their tuition dollars, and then fleeing to the protection of the bankruptcy courts, and that bankruptcy judges were unreasonably providing solace and shelter to these companies that had just defrauded students. So that seems to be the sort of underlying, if not sort of rationale, but the sort of the feeling that was in the air at the time, that colleges were fraudulent and bankruptcy judges were sheltering them.
It's an interesting justification because oftentimes within the bankruptcy industry, we realize that bankruptcy is a powerful tool to police against fraud, to clean up fraud.
Absolutely, right. An explicitly stated purpose of the United States court system is to protect against fraud, waste, and abuse. Right, and so to eliminate the oversight of the bankruptcy courts and the United States trustees and the creditors committees, which are all there to police against fraud, seems like a terrible way to solve this problem. And that's it's certainly one of the primary reasons I advance in my paper. Right, this is the problem that Congress wished to solve could not be solved with their proposed solution, with their actual solution.
Right, and as you point out, this provision in Title IV doesn't stop a company, a higher educational institution, from liquidating. They could file bankruptcy under Chapter 7. It just effectively prevents them from reorganizing.
That's right. And as I point out in the new paper, Higher Ed Do Not Resuscitate Orders, there's also concerns about fraud and abuse in the healthcare sector, which is an enormously larger sector. So Medicare and Medicaid combined are the federal government spends approximately 14 times more each year, almost $1 trillion a year on Medicare and Medicaid support for hospitals than it spends on supporting higher education institutions. Some estimates put the amount of fraud in healthcare at about $70 billion a year, which is about the same size as the total contribution the federal government makes to support higher education institutions. And yet, if a hospital or other healthcare provider wants to reorganize in bankruptcy, they can continue to receive Medicare and Medicaid. And so, I use this comparison in the new paper in part to highlight that colleges seem to be sort of uniquely disqualified from using bankruptcy reorganization, and that hospitals and other healthcare providers which suffer from similar problems of fraud are not prohibited in the same way.
It's an interesting comparison. So you have two industries, both of which have a large amount of government funding, both of which are maybe especially prone to fraud, or in which we would be particularly concerned about fraud on students or fraud on patients. And yet, as you point out, in the healthcare industry, Chapter 11 is available. Can you tell us some success stories in the healthcare industry that helps shed some light on what bankruptcy might be able to do for failing higher educational institutions?
Sure. Yeah. So there is a small rural hospital in Owington, Kentucky. It's got a population of something like 11,000 people. Their hospital, New Horizons Health Center, been on operation since the early 50s, and as a critical access hospital, meaning they serve predominantly a rural population, and they offer emergency services 24 hours a day. They're a critical access hospital, and they get extra payments from Medicare and Medicaid. But despite these additional payments, they just weren't able to make a go of it. In the early 2000s, they almost went under, and the USDA, I'm not quite sure why the USDA, but USDA loaned them $5.4 million. But still, a few years later, in 2015, they entered into bankruptcy. While in bankruptcy, they continued to receive Medicare and Medicaid funding, which was about 60% of their annual revenue. And they used bankruptcy to shed some debt. They had on their schedules, they listed assets of $7.6 million and liabilities of about $12 million. And they really used bankruptcy to discharge this excess debt and also to sell, able to use bankruptcy to sell the hospital to a physician group from New Jersey. Because they were able to discharge their debt and cleanse their assets through bankruptcy, it facilitated the investment of this physician group. So they bought the hospital, which provided some recovery for the creditors, but they also invested another $1 million in updating and modernizing the facility so that it could continue to serve the community in which it was located. And this is the kind of thing that we see bankruptcy do all the time to solve debt overhang problems, to allow facilities to attract new investment in refurbishing those facilities. That just would not occur if there was this debt overhang.
Now, so it's an interesting comparison, and I think you can learn a lot from looking at sort of success stories in the healthcare industry and how bankruptcy might help some institutions of higher education. A common criticism of the higher education industry is that there's just too many colleges, too many universities right now, and we're seeing a right sizing in the market. And that might be some justification for not needing a bankruptcy option for these institutions. How would you respond to that?
Even with a bankruptcy reorganization option, something in the order of 10% of acute care hospitals close every year. And I think in the 2000-2005 period, I saw a statistic recently that almost 20% of the acute care hospitals in the United States closed. And so bankruptcy doesn't do anything to prevent hospitals from closing, nor would I think that a bankruptcy reorganization option would prevent colleges from closing. In fact, we might think the opposite is true. So, Elizabeth Warren and Jay Westbrook some years ago wrote a paper about Chapter 11 that suggested that one of its primary benefits is sorting enterprises that are likely to be able to be successfully reorganized from those that cannot be. And their study had found that of entities that get so far as to propose a plan of reorganization, most are successfully confirmed, and those that are not able to confirm a plan are quickly sort of pushed out of the system and liquidated. So we might think that there are too many colleges, in part because they can't try to reorganize. They try to do out-of-court restructurings. They try to do academic reprioritization exercises. They create financial exigency plans, and they just limp along. Whereas if they were able to file, or they thought there was a benefit to filing a Chapter 11, they might sort of get in the process. They might hire financial advisors and attorneys to help them think about their reorganization, and they might find that once they're there, it turns out that they just realize they're not going to make a go of it. And so I think there's an argument to be made that sort of encouraging more filings would encourage college management to think more carefully about their options, and some would find that they just can't make a go of it anymore.
And one final sort of point of pushback, I suppose, is, the higher educational industry. I guess the failures that have attracted most of our attention, like Corinthian colleges, for example, or EDMC, or these for-profit institutions. And we do tend to look skeptically upon these institutions. Is that really who's mostly affected by these, or who else is affected that we might overlook by focusing solely on these really large for-profit institutions?
The enterprises that tend to be able to restructure out of court are wealthier institutions, are ones with larger endowments, right? So Sweetbriar College proposed closing while they still had almost $100 million endowment.
Wow.
And some of that was restricted, but the trustees thought, we will sort of sensibly plan for our winding down, and if we do have assets left over, we'll transfer those to other enterprises that, other colleges that will fulfill our charitable mission as well. Something like 85% of women's-only colleges have stopped becoming women's-only colleges. Now, whether that's because they've started admitting men, or because they've closed, or some other reason, they've struggled. HBCUs have struggled. And another example, perhaps, St. Paul's College was a teaching college in Lawrenceville, Virginia. It operated in Southern Virginia for about 125 years, a historically black college. It always served, predominantly poor folks from poor communities without a lot of resources, and so it always had a small endowment, didn't have a lot of budgetary flexibility, and eventually it closed. They tried to facilitate a sale to another historically black college, St. Augustine's, and it was too much for St. Augustine's to assume their $4 to $5 million in debt. Had St. Paul's been able to discharge that debt in bankruptcy, perhaps that would have facilitated the sale. So I think that it's certainly true that large for-profit colleges would benefit from changing the law. They are the most like other businesses, and therefore, in some ways, it's the easiest to say, right, they would benefit. But I think there are a lot of small colleges that could also benefit. And also, I'll probably also say this about large for-profit colleges. Bankruptcy is not for the benefit of their management. Right? It is for the benefit of their creditors, their students, the communities these colleges are located in, the staff, right? A recent study suggested that most students who attend colleges that close neither seek the discharge of their debt nor seek further student loans. So that means that most students who are at colleges that close just end up with a whole lot of debt and no degree.
Wow. And as we know from research on student loan debt, that is really the worst combination. People with student loan debt and not without having received the degree.
They've made an investment in their education. They've spent money on that, and they've gotten no credential in response. So they have non-dischargeable student loan debt. Should all these colleges stay open because students would be harmed? No, they shouldn't. Some of these colleges should still close, but the existing equity holders in these large for-profit colleges, bankruptcy is not for them, right? We look at these entities and we're sometimes upset with their practices. But in most large reorganizations, equity gets nothing, right? They lose their equity, and creditors get the new equity. And so I would really like to sort of reframe the narrative about who would benefit from restructuring even for-profit colleges. It would be students, it would be communities, it would be staff and workers more than it would be the prior owners.
Matt, thanks so much for your time. Do you have any concluding remarks you'd like to make about future scholarship or future research in this area that perhaps we should keep an eye on?
Sure. Thanks again so much for having me. I would say that if you're interested, this fall's National Conference of Bankruptcy Judges conference out in Las Vegas, the ABI and the ABLJ will be hosting jointly a symposium on bankruptcy in higher education with myself, Bob Rasmussen, Dalia Jimenez, and Karen Gross. So we'll be talking about various aspects, student loans, the colleges themselves, just all sorts of issues related to bankruptcy in higher education.
Fantastic. Thank you for bringing that to our attention, and that'll be a great panel. Professor Bruckner, thank you so much for your time today. This is clearly an important subject and one that we will want to pay close attention to. Again, you may find links to Professor Bruckner's research in the ABI newsroom, where you will also find links to nearly 200 other podcasts. Until next time, this is Drew Dawson, and thank you for listening to this edition of ABI Podcast.